Hello everyone. Today we are going to discuss about how a company is incorporated with the help of promoters and how the company comes into existence with the help of promoters under the company law. So let us start with the topic promotion. It refers to the entire process by which a company is brought into existence. It starts with the conceptualization of the birth of a company and determination of the purpose for which it is to be formed. The person who conceive the company and invest the initial funds are known as the promoters of the company. The promoters enter into preliminary contracts with the vendors and make arrangements for the preparation, advertisement, and circulation of prospectus and placement of capital. However, a person who merely acts in his professional capacity on behalf of promoters, example lawyer, chartered accountant, etc., for drawing up the agreement or other documents or prepares the figures on behalf of the promoter and who is paid by the promoter is not a promoter, right? Let's move further. The promoters have certain basic duties towards the companies formed. For number one, he must not make any secret profit out of the promotion of the company. Secret profit is made by entering into a transaction on his own behalf and then selling the concerned property to the company at a profit without making disclosure of the profit to the company or its members, right? The promoter can make profits in his dealing with the company provided he discloses these profits to the company and its members. What is not permitted is making secret profits, that is making profits without disclosing them to the company and its members. Number two, he must make full disclosure to the company of all relevant facts, including to any profit made by him in transaction with the company. Let's move further. In case of default on the part of the promoter in fulfilling the above duties, the company may rescind or cancel the contract made, and if he has made profit on any related transaction, that profit also may be recovered, right? Retain the property, paying no more for it than what the promoter has paid for it, depriving him of the secret profit, right? If these are not appropriate, example cases where the profit has altered in such manner that it is not possible to cancel the contract, or where the promoter has already received his secret profit, the company can sue him for breach of trust, damages up to the difference between the market value of the property and the contract price can be recovered from him, right? A promoter may be rewarded by the company for efforts undertaken by him in forming the company in several ways, right? The more common ones are the company may pay some remuneration for the services rendered. The promoter may make profits on transactions entered by him with the company after making full disclosure to the company and its members, right? The point number third, the promoter may sell his property for fully paid shares in the company after making full disclosure, right? So here the promoter may sell his property for fully paid shares in the company after making full disclosure. So after making full disclosure, he can do so. The promoter may be given an option to buy further shares in the company, right? So it says the promoter may be given an option to buy further shares in the company. Okay, let's move further. The promoter may be given commission on shares sold, right? Point number 6. The article of the company may provide for fixed sum to be paid by the company to him. However, such provision has no legal effect and the promoter cannot sue to enforce it. But if the company makes such payment, it cannot recover it back, right? If the promoter fails to disclose the profit made by him in course of promotion or knowingly makes a false statement in the prospectus where the person relying on that statement makes a loss, he will be liable to make good the loss suffered by that other person. The promoter is liable for untrue statement made in the prospectus. A person who subscribes for any share or debentures in the company on the faith of the untrue statement contained in the prospectus can sue the promoter for loss of damages sustained by him as the result of such untrue statement, right? We have now after that we have the situation incorporation by registration. So let us see what do we mean by incorporation by registration. The promoters must make a decision regarding the type of company, a public company or a private company or an unlimited company, etc., and accordingly prepare the documents for incorporation of the company. In this connection, the memorandum and articles of association are crucial documents to be prepared, right? Memorandum of association of a company. It is the constitution or charter of the company and contains the powers of the company. No company can be registered under Companies Act 1956 without the memorandum of association. Under Section 2 Clause 28 of the Companies Act 1956, the memorandum means the memorandum of association of the company as originally framed or as altered from time to time in pursuance with any of the previous companies law or the Companies Act 1956, right? The memorandum of association should be in any of the one form specified in the tables B, C, D, and E of the Schedule 1 to the Companies Act 1956. So the format is given there. Form in Table B is applicable in case of companies limited by shares. Form in Table C is applicable to companies limited by guarantee and not having share capital. Form in Table D is applicable to company limited by guarantee and having a share capital, whereas form in Table E is applicable to unlimited companies, right? Content of memorandum. The memorandum of association of every company must contain the following clauses. So these are the clauses. Name clause. The name of the company is mentioned in the name clause. A public limited company must end with the word limited, and a private limited company must end with the word private limited. The company cannot have a name which, in the opinion of the central government, is undesirable. A name which is identical with or nearly resembles the name of another company in existence will not be allowed. A company cannot use a name which is prohibited under the Names and Emblems Prevention of Misuse Act 1950, or use a suggestive of connection to the government or state patronage, right? Let's move further. Domicile clause. So there's the state in which the registered office of company is to be situated is mentioned in this clause. If it is not possible to state the exact location of the registered office, the company must state it, provide the exact address either on the day on which the company commences to carry on its business or within 30 days from the date of incorporation of the company, whichever is earlier, right? Notice in form number 18 must be given to the registrar of companies within 30 days of the date of incorporation of the company. Similarly, any change in the registered office must also be intimated in form number 18 to the registrar of companies within 30 days. Right? The registered office of the company is the official address of the company, where the statutory books and records must be normally. It says the registered office of the company is the official address of the company, where the statutory books and records must be normally be kept. Every company must affix or paint its name and address of its registered office on the outside of every office or place at which its activities are carried on. The name must be written in one of the local languages and in English, right? So let us see what is the object clause. This clause is the most important clause of the company. It specifies the activities which a company can carry on and which activities it cannot carry on. The company cannot carry on any activity which is not authorized by its memorandum of association. This clause must specify main objects of the company to be pursued by the company on its incorporation, objects incidental or ancillary to the attainment of the main objects, other objects of the company not included in point number 1 and 2 above. In case of companies other than trading corporation whose objects are not confined to one state, the states to whose territories the object of the company extend must be specified, right? It says the state to whose territories the objects of the company extend must be specified. Let's move further. Doctrine of ultra vires, right? it says any transaction which is outside the scope of the powers specified in the objects clause of the memorandum of association and trade and are not reasonable incidentally or necessary to the attainment of the objects is ultra vires the company and therefore void. No rights and liabilities on the part of the company arise out of such transaction, and it is nullity even if every member agrees to it, right? Consequence of ultra vires transaction: the company cannot sue any person for enforcement of any of its rights, right? No person can sue the company for enforcement of its right. The directors of the company may be held personally liable to outsiders for an ultra vires, right? However, the doctrine of the ultra vires does not apply in the following cases. So these are the cases: if an act is ultra vires of the powers the directors if an act is ultra vires of the powers of the directors but intra vires of the company is liable, right? So it says if an act is ultra vires of the powers of the directors but intra vires of the company, right, the company is liable, right? If an act is ultra vires the articles of the company but intra vires of the memorandum, the articles can be altered to rectify the error, right? Let's move further. If an act is within the powers of the company but is irregularly done, the consent of the shareholders will validate it, right? Point number 4: where there is ultra vires borrowing by the company or it obtains delivery of the property under an ultra vires contract, then the third party has no claim against the company on the basis of the loan, but he has right to follow his money or property if it exists as it is, and obtain an injunction from the court restraining the company from parting with it, provided that he intervenes before the money spent on or the identity of the property is light, right? So it says provided that he intervenes before the money is spent or the identity of the property is lost, right? The lender of the money to company under the ultra vires contract has a right to make director personally liable, right? So it says the final point: the lender of the money to a company under the ultra vires contract has a right to make director personally liable. So there will be personal liability of the director in that case. After this, let us see the liability clause. A declaration that the liability of the members is limited in case of the company limited by shares or guarantee must be given. The memorandum of association of a company limited by guarantee must also state that each member undertakes to contribute to the asset of the company such amount not exceeding specified amounts as may be required in the event of liquidation of the company. A declaration that the liability of the members is unlimited in case of the unlimited companies. It says a declaration that the liability of the members is unlimited in case of the unlimited companies must be given. The effect to this clause is that in a company limited by shares, no member can be called upon to pay more than the uncalled amount on his shares. If his shares are already fully paid up, he has no liability towards the company, right? Let's move further. The following are exceptions to the rule of limited liability of members, right? Let us see. Now, point number 1: if a member agrees in writing to be bound by the alteration of memorandum article of association requiring him to take more shares or increasing his liability, he shall be liable up to the amount agreed to by him, right? Let's move further. Point number 2: if every member agrees in writing to re-register the company as unlimited company and the company is re-registered as such members will have unlimited liability, right? Let's move further. Point number 3: if to the knowledge of a member the number of shareholders has fallen below the legal minimum, 7 in case of public limited company and 2 in case of private limited company, and the company has carried on business for more than 6 months, while the number is so reduced, the members for the time being constituting the company would be personally liable for debts of the company contracted during that time, right? After that, we have the capital clause. The amount of share capital with which the company is to be registered divided into shares must be specified, giving details of the number of shares and types of shares. A company cannot issue share capital greater than the maximum amount of share capital mentioned in this clause without altering the memorandum. Right? Association clause. A declaration by person for subscribing to the memorandum that they desire to form into a company and agree to take the shares placed against their respective name must be given by the promoters. Right? Let us see what do we mean by articles of association. The articles of association contain the rules and regulation of the internal management of the company. The article of association is nothing but a contract between the company and its member, and also between the members and members themselves, and that they shall abide by the rules and regulations of the internal management of the company specified in the articles of association. It specifies the rights and duties of the members and directors. The provision of the articles of association must be in conflict, must not, as it says, the provision of the articles of association must not be in conflict with the provisions of the memorandum of association. In case such a conflict arises, the MA will prevail. Right? Normally, every company has its own articles of association. However, if company does not have its own article of association, the model article of association specified in Schedule 1, Table A will apply. A company may adopt any of the model forms of article of association with or without modifications. The article of association should be in any of the one form specified in tables B, C, D, and E of Schedule 1 to the Companies Act 1956. Form in table B is applicable in case of companies limited by the shares. Form in table C is applicable to the companies limited by guarantee and not having share capital. Form in table D is applicable to company limited by guarantee and having a share capital, where form in table E is applicable to unlimited companies. However, a private company must have its own article of association. Right? The important items covered by the articles of association include, so these are the following items: power, duties, rights and liabilities of directors, power, duties, rights and liabilities of members, rules for meeting of the company, dividends, borrowing power of the company, calls on shares, transfer and transmission of shares, forfeiture of shares, voting powers of members, etc. Alteration of articles of association. So how it is done: a company can alter any of the provision of the articles of association subject to provisions of the Companies Act and subject to the condition contained in the memorandum of associations of the company. A company, by special resolution at a general meeting of the members, alter its articles, provided that such alteration does not have the effect of converting a public limited company into a private company, unless it has been approved by the central government. Right? The article must be printed, divided into paragraphs and numbered consequently, and must be signed by each subscriber to the memorandum of association, who shall add his address, description and occupation in the presence of at least one witness, who must attest the signature and likewise add his address, description and occupation. Right? The articles of association of the company, when registered, bind the company and members thereof to the same extent as if it was signed by the company and by each member. Right? Registration of the company, the most important point. Once the documents have been prepared, vetted, stamped and signed, they must be filed with the registrar of the companies for incorporating the company. The following documents must be filed in this connection. Right? These are the following documents: the memorandum of association, an article of association, and number 2, an agreement, if any, which the company proposes to enter into with any individual for appointment as its managing director or whole time director or manager. Point number 3, a statutory declaration in Form 1 by an advocate, attorney or pleader entitled to appear before the High Court, or a company secretary or chartered accountant in whole the time practice in India, who is engaged in formation of company, or by a person who is named as director or manager or secretary of the company, that the requirements of the Companies Act have been complied with in respect of the registration of the company and matters precedent and incidental thereto. Right? In addition to the above, in case of public company, the following documents must also be filed. Right? These are following documents additional. Number 1, written consent of the directors in form number 29 to agree to act as directors, the complete address of the registered office of the company in form 18, details of the directors, managing director and manager of the company in form 32, Certificate of incorporation. Once all the above documents have been filed and they have found to be in order, the registrar of companies will issue certificate of incorporation of the company. This document is the birth certificate of the company and is proof of the existence of the company. Once the certificate is issued, the company cannot cease its existence unless it is dissolved by order of the court. Right? Commencement of business. A very important point. A private company or a company having no share capital can commence its business immediately after it has been incorporated. However, other companies can commence their activities only after they have obtained certificate of commencement of business. For this purpose, the following additional formalities have to be complied with. Number one, if company has share capital and has issued a prospectus, then share up to the amount of minimum subscription must be allotted. After that, point B, every director has paid to the company. It says every director has paid to the company on each of the shares which he has taken the same amount as public have paid on such shares. Right? Every director has to pay to the company. It says every director has to pay to the company on each of the shares which he has taken the same amount as the public have paid on such share. Right? And after the point number third, the point number C, under point this is the this is point number C. No money is or may be, it says no money is or may become payable to the applicants or shares or debentures for failure to apply for or to obtain permission to deal in those shares or debentures in any recognized stock exchange. Right? It says no money is or may become payable to the applicants of shares or debentures for failure to apply for or to obtain permission to deal in those shares or debentures in any recognized stock exchange. Right? Let's move further. The point number D, a statutory declaration in form 19 signed by one director or the employee, company secretary or a company secretary in whole time practice that the above provisions have been complied with must be filed. Right? It is these are the further additional documents which are supposed to be filed, as it has been said. The following additional these are the following additional formalities. So these are the these are the additional formalities which have to be complied with. Right? I correct. These are the formalities which have to be complied with. Right? So this is a second formality. If a company has share capital but has not issued a prospectus, then it must file a statement in lieu of prospectus with the registrar of companies. Right? Every director who has paid to the company on each of the shares which he has taken the same amount as the other members have paid on such shares. Right? A statutory declaration in form 20 signed by one director or employee, company secretary or a company secretary in whole time practice that the above provisions have been complied with must be filed. Right? Once the above provisions have been complied with, the registrar of companies grants certificate of commencement of business, after which the company can commence its activities. Right? So these are the points. As it says, the following additional formalities have to be complied with. So these are the formalities which have to be complied with. Right? After which it says once the above provisions have above provisions have been complied with, the registrar of companies grant certificate of commencement of business, after which the company can commence its business. Right? Alright. So with this we have gone through all the important provisions. We have gone through all the important steps, after which a company is incorporated. A company comes into existence with the help of the promoter. So these are the important points, right, which I have gone through. So with this, we have come to the end of this topic, right? So we have with this we have come to the end of this topic. Okay. So thank you very much.